Imagine a really high-stakes legal drama unfolding right in the heart of a young democracy. The highest court is being asked, essentially, has Parliament really held its president accountable?
Yeah, it's a fundamental question.
And today, that's exactly what we're diving into, a landmark South African case tackling these very issues.
We're unpacking the economic freedom fighters and others v. Speaker of the National Assembly case. You might see it cited as 2017 ZACC 47.
Okay.
And this was a complex legal fight. You have major opposition parties, the EFF, UDM, COPE, later joined by the DA, all going up against the Speaker of the National Assembly and then President Jacob Zuma.
Right. And at its heart, this case, it's really about their fundamental constitutional obligation, isn't it?
Okay.
Parliament holding the head of state accountable.
Exactly. And the whole backdrop is the, infamous Nkandla saga and what the public protector found. It really throws the spotlight on checks and balances.
Absolutely. So our mission today, for you listening, is to give you a clear, sort of structured look at this. We'll cover the key legal issues, the arguments from both sides, which were quite powerful.
Definitely. And how the Constitutional Court reasoned its way through it, the final decision, and importantly, the lasting impact this judgment actually had on South Africa's constitutional democracy.
Think of it as your shortcut to getting properly informed on a really critical legal precedent.
Okay, so to really get why this case even ended up in court, we need to rewind a bit to the Nkandla saga.
Yeah, the context is crucial here.
It really is. This was the huge controversy over the extensive upgrades made to President Zuma's private home in Nkandla. The key thing, significant public funds were used.
And this wasn't just political noise, right? It really gripped the country.
Oh, absolutely. And it led to the public protector, who's an independent constitutional watchdog, remember releasing a pretty damning report back in March 2014.
What did it say?
Well, her findings were clear. She concluded President Zuma had improperly benefited from these upgrades, and she recommended specific remedial action that he should pay back a reasonable percentage for the non-security stuff and also reprimand the ministers involved.
Okay, so a clear directive from an independent body. What happened next? Did the president comply?
Well, no, that's the crux of it. The president didn't implement that remedial action.
He just ignored it.
Effectively, yes. And crucially, the National Assembly Parliament, its initial response was to pass resolutions that basically let the president off the hook. They essentially absolved him of liability.
So Parliament sided with the president over the public protector initially.
That's how it played out at first. And that inaction, that refusal to enforce the findings, is what led the Constitutional Court to step in the first time.
Okay, so this is EFF 1.
Precisely. The first judgment, EFF 1, came down in March 2016. And the court's findings were, frankly, groundbreaking.
How so?
It declared President Zuma's failure to comply with the public protector's remedial action was inconsistent with the Constitution and invalid. Full stop.
Wow.
And it didn't stop there. It also found that the National Assembly's resolution, the one absolving him, also inconsistent with the Constitution and unlawful.
So the court slapped down both the president and Parliament.
In effect, yes. It powerfully stated that neither the president nor Parliament could just second-guess the public protector's binding findings. It was a huge boost for the authority of that office.
That sounds like a really strong statement from the judiciary.
Whoa.
How did President Zuma react to that ruling?
Well, the day after the judgment, April 1st, 2016, President Zuma gave a public address. He said he welcomed and respected the judgment.
But there's always a but.
Well, he also claimed he never knowingly or deliberately violated the Constitution. He tried to frame it as not being, corrupt.
Okay, so he respected the judgment, but didn't quite take full responsibility in the way some might have expected.
You could say that. And despite that statement, the opposition parties clearly felt Parliament still hadn't acted sufficiently on the court's judgment.
Right, because the judgment found Parliament had also failed. So what did Parliament do after EFF 1?
Well, there were several attempts by opposition parties to trigger accountability mechanisms in Parliament. For instance, just days after the judgment, April 5th, 2016, the Democratic Alliance tabled a motion for the president's removal.
Under Section 89, the impeachment clause.
Exactly, citing a serious violation of the Constitution based on the EFF 1 findings. That motion was debated, there was a vote, but ultimately it was defeated.
Okay, so an attempt was made, but it failed.
Yes. And interestingly, that specific DA motion didn't ask for an ad hoc committee to investigate first. They went straight for the removal vote.
Even though ad hoc committees had been used before for accountability issues?
Right. There were precedents, like for Nkandla itself earlier and another situation in 2015, but not this time.
Were there other ways Parliament tried to hold him accountable?
Well, yes. Over the next few months, the president did face question and answer sessions in the National Assembly about the whole Nkandla issue and his failure to act on the Public Protector's report.
So direct questioning.
Direct questioning. And then there were two more separate motions of no confidence under a different part of the Constitution, Section 102.
Ah, different from Section 89 impeachment.
Yes. Section 102 is more about political confidence, less severe consequences. One was in November 2016, another in August 2017. The second one even used a secret ballot, which was quite significant.
And the result?
Both debated, both voted on, both defeated.
Okay, so multiple attempts, impeachment motion, Q&A, no confidence motions, all ultimately unsuccessful in removing the president or imposing direct consequences through Parliament.
Precisely. And this sequence of events, the failed motions, the lack of maybe a dedicated new investigative process after EFF 1, that really sets the stage for this second major legal challenge.
The one we're focusing on today, the opposition clearly felt Parliament still hadn't done its constitutional duty.
Exactly. That's why the EFF, UDM, COPE, and DA brought this new case. They argued the National Assembly had fundamentally failed to fulfill its constitutional obligations arising from EFF 1.
And the court agreed to hear it based on its exclusive jurisdiction over Parliament's constitutional duties.
Correct. The jurisdiction wasn't really in dispute. The whole battle then boiled down to, essentially, two core questions for the court.
Okay, let's break those down. What was the first key legal question the court had to tackle?
The first one was all about the tools. Did the National Assembly fail to put in place the necessary mechanisms and processes to hold the president accountable, specifically under Section 89, the impeachment section?
Right. And just remind us, Section 89, what does that involve again?
It's a really serious provision. Section 89 lays out very strict grounds for removing a president. It's not just a political whim. The grounds are A, a serious violation of the Constitution or the law, B, serious misconduct, or C, inability to perform office functions.
Serious stuff.
Very. And it needs a hefty vote, at least 2/3 of all National Assembly members. Plus, if you're removed under A or B, serious violation or misconduct, you lose your presidential benefits. So it has real teeth.
Okay, given how serious Section 89 is, what was the applicant's argument about the mechanisms? Were they saying Parliament just wasn't equipped for it?
That was exactly their point. Their core argument was that the National Assembly hadn't created specifically tailored rules and procedures just for Section 89. They argued you needed a clear process, including, crucially, some kind of preliminary inquiry to figure out if those serious grounds actually existed before you even get to a full impeachment debate.
So like a fact-finding step first.
Essentially, yes. They felt the existing general rules, like the ones for setting up ad hoc committees for any old task or just tabling a motion, were simply not good enough for something as grave and specific as impeachment. They wanted a dedicated playbook for it.
That seems logical for such a major constitutional process.
Yeah.
How did the Speaker, representing Parliament, push back?
The Speaker argued, quite forcefully actually, that adequate and flexible mechanisms did already exist. She pointed specifically to Rule 253, which allows for these ad hoc committees.
The ones mentioned earlier.
Exactly. She argued these committees could be set up for any specific task, and that definitely included investigations or inquiries needed for a Section 89 process. She even cited past examples where they were used for accountability, like removing a national director of public prosecutions back in 2007.
So we have the tools, they're flexible.
Pretty much. She also mentioned the other accountability methods, like the Q&A sessions and the Section 102 no confidence motions, as part of the overall toolkit.
Okay.
And then she added a really interesting point. She noted that a subcommittee of the National Assembly's own Rules Committee was, at that very time, already looking into whether specific Section 89 rules were needed.
Parliament was already working on it.
Apparently so. And she pointed out that the political parties involved, including the applicants in this court case, hadn't actually provided the input that subcommittee had requested from them.
Wow, okay, that adds a layer of complexity. It sounds like Parliament's defense was partly, we have tools, and we were even looking at refining them, but you didn't engage with that process.
That was certainly part of their argument, which leads us right into the second big question before the court.
Which was?
Did the National Assembly fail in its separate duty to actually scrutinize the president's constitutional violation? Remember, EFF 1 had already established that violation had occurred.
So forget the rules for a second. Did Parliament actually do anything concrete about the violation the first court case confirmed?
That's what the applicants argued hadn't happened. They claimed that since the EFF 1 judgment back in March 2016, the National Assembly had done, in their words, nothing substantive to properly scrutinize the president's violation or to determine how severe it was in the context of Section 89.
Nothing. That sounds like a strong claim. I assume the Speaker disagreed.
Oh, strongly. The Speaker countered that the National Assembly had indeed acted. She listed the concrete steps taken, that Section 89 removal motion by the DA in April 2016 debated and voted on.
Even though it failed.
Even though it failed. Then, the two Section 102 no-confidence motions in late 2016 and mid-2017 again, debated and voted on.
Also failed, but processes happen.
Exactly. And she also pointed to all those question and answer sessions where the president was quizzed on Nkandla. Her key argument was this. Just because the motions were defeated doesn't mean Parliament failed in its duty. The act of debating, considering, and voting itself constituted accountability.
That's a fascinating point. Does accountability mean achieving a certain outcome, like removal, or is it fulfilled by going through the established parliamentary processes regardless of the vote's result?
That was really a central tension, a very tricky legal and political line to walk.
Yeah.
So let's see how the Constitutional Court split on this.
Right. The court wasn't unanimous here, was it? There was a majority judgment and a dissent.
Correct. Two very different paths emerged. You had the majority judgment written by Justice Jafta and then a strong dissenting judgment written by Deputy Chief Justice Zondo with the Chief Justice Mogoeng concurring.
Let's unpack the majority view first. On that first question about mechanisms and rules, did they agree with the applicants that special rules were needed?
Yes, they did. The majority found that Section 89 implicitly, meaning it wasn't explicitly written but was implied, imposes an obligation on the National Assembly to make specifically tailored rules for impeachment.
Why implicitly?
Their reasoning was that the terms used in Section 89, like serious violation and serious misconduct, are quite vague. Therefore, Parliament had a duty to define these terms more clearly and set up a proper institutional process to determine if they'd been met.
So the existing rules weren't good enough in their eyes.
Correct. He found the existing rules, including the ad hoc committee route, were insufficient. Why? Because they lacked a set procedure. They could be subject to, as the judgment put it, the generosity of the Speaker, and critically, they posed a risk.
A risk of what?
A risk that a majority party could use its numbers in committees, because committee membership is proportional to essentially shield a president by blocking an impeachment complaint from ever even reaching the full assembly for a vote.
Oh, okay. So a procedural safeguard was missing?
Exactly. And they emphasize that some kind of preliminary inquiry or process to establish the grounds is a necessary condition before you even start formal Section 89 proceedings. It's not just optional.
So the majority said Parliament needed specific, codified rules with a preliminary step. What about the second question? Had Parliament actually scrutinized the president's violation after EFF 1?
On that point, the majority held that the National Assembly did fail to hold the president accountable as required by Section 89(1 following that first judgment.
How did they justify that?
They found that the DA's Section 89 motion back in April 2016 was procedurally flawed. Why? Because it wasn't preceded by what they called the necessary antecedent determination by the Assembly itself that a ground for impeachment actually existed.
So it jumped the gun, procedurally speaking.
According to the majority, yes. They also noted the president wasn't formally given a chance to defend himself within a proper, dedicated Section 89 process, and they specifically distinguished the Q&A sessions and the Section 102 no-confidence motions as not meeting the unique, higher bar set by Section 89.
Okay, so the majority found failures on both fronts.
Yeah.
Lack of proper rules and failure to properly scrutinize according to those missing rules. What remedy did they order?
They declared the National Assembly's failures unconstitutional, and they issued a direct order. The National Assembly had to make specific rules for presidential removal under Section 89(1 without delay.
Get the rules sorted.
And second, it had to actually determine whether the president had breached Section 89(1)(a) or B, the serious violation or misconduct grounds, also without delay. They were very clear this wasn't judicial overreach, but simply making Parliament fulfill its constitutional job.
Strong order.
Yeah.
But then we have the dissent, led by Deputy Chief Justice Zondo, who called this judicial overreach. What was their counter-argument?
The dissent took a fundamentally different view. On the rules and mechanisms, they argued strongly that the National Assembly did have adequate and flexible tools already, specifically those ad hoc committees.
They thought ad hoc committees were sufficient.
Yes. They even pointed out that the applicants themselves, at one point in the legal arguments, had actually conceded that such mechanisms were available. The core of the dissent's argument here was about the separation of powers.
How so?
They felt the court shouldn't be telling the National Assembly how to scrutinize the executive or exactly what mechanisms to set up. They saw that as Parliament's job, its discretion. They even referenced the first EFF judgment to support this idea of parliamentary discretion.
And what about the fact Parliament was apparently already reviewing the rules?
The dissent hit that point hard, too. They criticized the applicants for not participating in the National Assembly's own subcommittee process that was already looking into improving the Section 89 rules. Sort of a, you can't complain if you didn't engage argument.
Okay, a very different view on the rules. What about the second issue, the actual scrutiny of the president's violation? Did the dissent think Parliament had done enough?
They absolutely did. The dissent argued that the National Assembly did hold the president accountable. They pointed squarely at that defeated Section 89 motion in April 2016 and the two defeated no-confidence motions.
Using the Speaker's argument that the process itself was accountability.
Precisely. They asserted that the outcome of the vote, the fact the motions failed, doesn't mean an accountability process didn't happen. The debate and vote was the process.
And what about the need for a specific inquiry into the Nkandla violation?
Here's where the dissent had a really interesting take. They argued a formal fact-finding inquiry specifically for Nkandla was unnecessary because the EFF1 judgment had already done that. The first judgment had definitively established the president violated the Constitution.
So the facts were already settled by the court?
In their view, yes. They argued that determining the seriousness of that violation, which is the key term in Section 89, isn't a factual question needing more investigation. It's a value judgment for the elected members of the National Assembly to make.
A political judgment, essentially.
A political and constitutional value judgment, yes, not something requiring another formal inquiry. They also raised a fairness point, questioning whether it was right to ask Parliament to effectively re-adjudicate an issue where many members had already expressed their view through previous votes.
So the dissent saw the existing processes as sufficient, felt the seriousness was a political call for MPs, and viewed the majority's order as the court overstepping into Parliament's domain.
Exactly. They would have dismissed the application entirely, calling the majority's decision quite strongly an unconstitutional encroachment and judicial overreach. They believed Parliament was doing its job, and the court's order served no real practical purpose.
Two very compelling but fundamentally opposed views on the separation of powers and parliamentary duty. So when the dust settled, what was the final binding order from the Constitutional Court?
The court, ruling by majority, issued a clear and binding order. It explicitly declared two things. One, the National Assembly's failure to make specific rules for removing a president under Section 89 violated the Constitution and was invalid.
Okay, failure on the rules.
Two, the National Assembly's failure to determine whether President Zuma had actually breached Section 89(1, or B, the serious violation or misconduct grounds, was also inconsistent with the Constitution.
Failure on the scrutiny using those grounds.
Correct. And flowing from that, the court ordered the National Assembly to comply with both these obligations without delay. Essentially, fix the rules and then use them to make a determination regarding the president.
So what does this all mean in the bigger picture? What's the real significance and lasting impact of this judgment on South Africa's democracy?
Well, it's hugely significant. Firstly, it massively strengthened the parliamentary oversight mechanisms, specifically for presidential accountability. It pushed beyond just debates or general no-confidence votes.
That's so.
By mandating a clear, defined, and importantly rigorous process specifically for impeachment under Section 89, it clarified that Section 89 is distinct, it's more serious than a Section 102 no-confidence vote, and it absolutely requires specific procedural rules, including that preliminary assessment of the grounds.
So it drew a much clearer, brighter line around what true impeachment accountability looks like in Parliament.
It really did. And secondly, it powerfully reaffirmed the Constitutional Court's role as the ultimate guardian of the Constitution. It showed the court was willing and able to ensure that even Parliament, the legislative branch, fulfills its own constitutional duties.
Even when that involves delving into sensitive separation of powers territory.
Especially then. It showed judicial oversight extends to parliamentary process when constitutional obligations are at stake. Thirdly, the emphasis on that preliminary inquiry and giving the president a proper chance to respond highlights the importance of procedural fairness, even in these intensely political processes.
Fairness matters, even for the president facing removal.
Absolutely. And finally, it was essentially a direct call to action for Parliament. It told them, point blank, to develop robust internal procedures for handling these incredibly serious matters concerning the head of state, making sure their own processes align fully with the Constitution.
Wow, what an incredible journey through a case that really pushed the boundaries of power, accountability, and the roles of different state institutions in a democracy.
It truly did. We've seen this complex interplay, the public protector, the president, parliament, the courts, and how it ultimately resulted in forging, arguably, a stronger legal framework for holding the highest office accountable.
So thinking about this, what does it all mean for you, our listeners, whether you're an informed citizen or maybe studying law?
Well, consider this. How much does a nation's commitment to having clear, defined rules for holding leaders accountable actually matter, even when the outcome of using those rules is uncertain or politically charged?
Does having the process right, even if the result is contentious, protect the Constitution itself? Does it shape the country's democratic identity?
And perhaps what lessons could other democracies, maybe grappling with their own challenges around executive oversight and impeachment, draw from the South African experience? It's quite a specific context, but the principles might resonate.
Definitely food for thought.
Yeah.
And looking forward, how might that balance between political discretion, Parliament's right to manage its affairs, and legal obligation, the duties imposed by the Constitution, continue to evolve, especially in parliamentary systems?
And maybe a final thought for you. What role should citizens play in demanding this kind of rigorous, procedurally sound accountability from the people they elect to represent them?
Lots to ponder long after this deep dive ends.